All right, we're back on the record on State versus Loyd. He's present with his attorneys. The state attorney's office is present. This next group includes panel 3 and panel 4, and the 2 jurors from the 9 o'clock who were not here, so we have 12. Let's bring them in. Apparently we're not. It's fine.
Or affirm that you will answer truthfully all questions asked of you as potential jurors. So help you God. Thank you.
All right, good morning, everyone. Have a seat, please. All right. Welcome back to day 2 of jury selection. Let me ask, can all of you hear me with this mask on? Is anybody having any problems hearing me? Nope? Okay. All right. As I told you, we do these cases, or the jury selection for these cases, in multiple groups or in multiple days. Today is individual questioning day. I'm going to instruct you and give you some facts about the case as a group. Then I'm going to send you back into the jury room and we're going to talk to you one at a time. We will be breaking for lunch at some point, but we're going to try and get through as much as we can prior to that. So, as I indicated to you on Friday, this is a death penalty case, or what we call a capital case. These cases are tried in 2 phases, the guilt phase and the penalty phase, if the penalty phase becomes necessary. The guilt phase is the same as all other criminal trials. It's where you decide whether someone's guilty or not. So I'm going to start by telling you what Mr. Loyd is charged with. And he's charged by indictment. This is a copy of the indictment in my hand. It's a piece of paper that tells him, this is what we're accusing you of doing. These are the crimes you're being charged with. You have to tell people what you're charging them with, what you're accusing them of doing. This is how Florida does it. This indictment is not evidence of guilt, and you may not use it as such. And by that, what I mean is, just because someone's been charged with a crime does not mean they're guilty, and you can't make any assumptions off of this, all right? So he's charged in count 1 with first-degree murder with a firearm of a law enforcement officer. Count 2, attempted first-degree murder with a firearm of a law enforcement officer. Count 3, aggravated assault with a deadly weapon. Count 4, carjacking with a firearm. And count 5, possession of a firearm by a convicted felon. And as I indicated, the case is tried in 2 phases. Phase 1 is the guilt phase. It's the same, it's conducted pretty much the same way we do all criminal cases. You're going to be asked to sit in the courtroom, listen to the evidence, listen to witnesses testify, see physical evidence, same as you do in every criminal case. At the end of that, you'll be provided jury instructions from me, which are the law that you must follow, and you will be asked to return a verdict of guilty or not guilty on all counts. And your verdict must be unanimous on all counts, meaning each juror must agree to either acquit or convict on each count. Only the first count, murder in the first degree, qualifies for the death penalty if convicted of murder in the first degree. The burden of proof on the state is the same in the guilt phase of a capital case as it is for every other criminal case. It is proof beyond a reasonable doubt. The instruction you will receive on reasonable doubt is identical to the one given in all other criminal cases. The burden on the state is not higher because of the potential penalty. When you're deciding guilt in phase 1 of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty or not guilty, or guilty of a lesser included offense. And we expect you, as jurors, to carefully consider the facts before you reach a decision. The fact that a defendant may face a death penalty is to play no part at that stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, the jury will then reconvene for the purposes of rendering a verdict as to which sentence, death or life imprisonment, without the possibility of parole, should be returned. That is the penalty phase. If that happens, a special set of rules and instructions come into play. I'm going to give you an overview of the penalty phase right now. There are detailed instructions that are given to you if that should happen. Because the death penalty in Florida is reserved for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty. So they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The prosecutor will rely on something called aggravating factors. The state is required to prove these factors beyond and to the exclusion of a reasonable doubt. They are limited in number by statute, and they are the reasons, the legal reasons they believe that the death penalty is the appropriate sentence. The defendant relies on something called mitigating circumstances or mitigators. Mitigating circumstances do not need to be proven beyond a reasonable doubt. They only need to be proved by the greater weight of the evidence. Mitigating circumstances are not limited by statute, and they may include matters relevant to the defendant's background or character and circumstances surrounding the offense. They will be offered as a basis for a verdict of a sentence of life in prison without possibility of parole. Life in prison without parole in Florida means exactly that. The defendant will die in prison. We do not have parole in this state. Before you may vote the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. Once all the evidence is presented to you, you will retire to the jury room to undergo with detailed instructions to undergo the process of weighing aggravating factors and mitigating circumstances to determine the proper punishment. This is not a mechanical or mathematical process. In other words, you're not back there to add up how many aggravators were proved and how many mitigators were proved. It's not how you do this. The law contemplates that different factors may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, that verdict must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. Again, this is just intended to give you a broad outline of the penalty phase, just in case you end up in a penalty phase as a juror here. Let me also say this. The fact that I'm talking about the death penalty is not to be taken by you as any indication, one way or another, as to whether or not this is a case that justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility, and we need to be sure that you can fulfill your duty as jurors should you be in a penalty phase. We're going to be asking you some questions, as I said, individually. I'm going to tell you what some of the questions are so that you can think about them while you're in the jury room, because some of these are not questions that you are normally asked in your life. So you're going to be asked if you have any religious or moral objections to the death penalty. You're going to be asked whether you're someone who believes that there are certain types of cases where the death penalty should be automatic, or whether you believe that in every first-degree murder case, the death penalty should be automatic. In the state of Florida, there is no automatic death penalty for any case, including death penalty, or including first-degree murder cases. We may ask you, what your position is on the death penalty, how you feel about the death penalty. Can you weigh the aggravators and mitigators as I described and vote for either life or death? And you may also be asked if you're so opposed to the death penalty for whatever reason that you could not consider it as a penalty under any circumstance. Many people have very strong feelings about the death penalty one way or another. The fact that you have such feelings does not disqualify you to serve as a juror, as long as you can put those feelings aside and apply the law as I instruct you. In other words, you must be willing to be bound by your oath as a juror to obey the laws of the state in delivering your verdict. Changing gears slightly, Mr. Loyd has raised the defense of not guilty by reason of insanity in this case. This is the one time the burden is on the defense in the guilt phase of a case. It's their job to prove by clear and convincing evidence that he was insane. I'm going to read you a small portion of the insanity instruction that's given to jurors. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The instruction is longer than that, but that's all you need to know for today's purposes. We are going to be asking you about your feelings about that type of defense and whether, if the evidence proved to you that he was not guilty by reason of insanity, you could vote not guilty in this case. And lastly, I'm going to read you a statement of facts about the case. This is a small blurb on this. On the morning of January 9, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. This last portion I just read to you about Sade Dixon and her unborn child and the conviction and sentence cannot be used by you in any way as a basis for finding Mr. Loyd guilty in this case. That evidence is being offered. It's a completely separate case. The evidence is being offered for a different reason that you will be instructed on. And so we'll be asking you about your ability to put that aside during the guilt phase of this case. All right. Now, by a show of paddles only, how many of you, prior to being called here for jury duty, have heard about this case? Just raise your paddles, please. Juror in seat 57, 58, 59, 1, 2, 4. You can put your paddles down once I call your number. 9, 10, and 12. So 57, 58, 59, 1, 2, 4, 9, 10, 12. Anybody I missed? All right. Those of you who have heard about the case, do you have an opinion about Mr. Loyd's guilt in this case based on what you've heard? If you do, raise your paddles. Juror number 2, juror number 9, juror number 12. Did I miss anybody? No. All right. Who? 58? Oh, 58. Sorry, sir. All right. So I've got 58, 2, 9, and 12. Correct? All right. Juror number 58, if you'll remain in the courtroom with us, the rest of you will retire to the jury room. There's coffee in there. We'll be back with you in just as soon as we can. Thank you. You're juror number 734, right? Yes. Okay.
Seated.
I got to wait till they're out of the court. Well, I guess I can start by telling you this. Number one, can you hear me with the mask on?
Yes.
Can you hear me clearly, or do you need me to take it off?
I hear you clearly.
Okay. You have your microphone, right?
Yes.
Okay. There aren't any right or wrong answers to the questions we're going to be asking you. There's just what you actually believe. So just be honest in answering the questions and you'll be fine, okay? So what have you heard about this case?
Just what's been on the news. Pretty much all the charges you mentioned, and then just conversations about back and forth about, what happened and whatnot.
You were talking to other folks?
Yes.
Family, friends?
Yes.
Coworkers?
Yes.
So how much news coverage did you watch?
Not sure, just basically whatever is on the news, since that time and now.
Do you watch the local news regularly?
Yes.
So since this occurred, have you watched this on the news?
Yes.
Did you watch any of the first trial?
Some of it.
Some?
Yeah.
Okay. So you followed it fairly closely. Is that fair?
I saw some of it in passing.
Okay. You said you'd formed an opinion as to Mr. Loyd's guilt based on what you'd seen. Can you tell me what that opinion is, please?
I would say, opinion of guilt.
Okay. So jurors have to be able to presume that Mr. Loyd is innocent until and if he's proven guilty. Do you believe that you could make that presumption, or would you start the trial thinking he's guilty?
Sorry, I didn't hear the last part, second half.
I'm sorry, or would you start the trial thinking he's guilty?
I feel like Yeah, it would be difficult for me to not.
To put aside your feelings about
Yes.
him being guilty?
Yes.
All right. State,
State moves.
defense? All right. Thank you, sir. I don't think this is the case for you because of that. We appreciate your willingness to serve and your being here today. You are free to go. Thank you. You see the juror in seat number 2, please? This is panel 4. Here? Okay. All right, ma'am. Good morning. You're juror 614, is that correct?
Yes, ma'am.
All right. There aren't any right or wrong answers, okay? We just need you to tell us the truth. As long as you're honest, you're fine. We're not looking for a particular answer from you. You indicated that you'd seen or heard something about this case, is that correct?
Yes, ma'am.
Can you tell me what you've seen or heard?
I saw when it was actually happening on the news around here about his girlfriend at the time and the baby, and then the officer that was shot as well at Walmart.
All right, so you watched it back when it first occurred, correct?
Yes, ma'am.
Talk about it with friends, family, coworkers?
Yeah.
Okay. Subsequent to that, did you watch anything on the news, see anything on the news?
I did not.
Did you read anything about the case, either in the paper, Facebook, anything like that?
I have not.
Have you talked to anybody about it?
Yes.
Okay. What brought up the conversation, if anything?
A couple of my coworkers just enjoy like crime shows and stuff, so they talk about it at work.
Okay. It's not that uncommon. You indicated you'd formed an opinion as to whether or not Mr. Loyd is guilty based on that. What is your opinion, ma'am?
I believe he's guilty.
Jurors are required to begin trials presuming Mr. Loyd to be innocent. Some folks can do it, some can't. Can you presume him to be innocent, or are you going to start the trial thinking he's guilty?
I'd probably start the trial thinking he's guilty.
All right, thank you. State?
State moves.
Any objections? All right, not the case for you, but thank you for your willingness to serve. You're free to go, ma'am. Thank you.
Thank you.
Juror in seat number 9, again, panel 4. She can just sit in the second chair coming in.
Got it.
There you go. Good morning.
Good morning.
Can you hear me?
Yes, ma'am.
All right. We just have a few questions for you. There aren't any right or wrong answers to these questions. There's just what you actually think or believe. So just be honest with us, okay?
Yes, ma'am.
You indicated that, let me verify, you're juror 667, correct?
Correct.
All right. You indicated that you'd heard something about this case. Can you tell me what you've heard, please?
Well, I've been following it from the beginning,
Okay.
and it's really, I don't agree with, everything that, I believe that it's a guilty thing.
You believe he's guilty?
Yes.
Do you believe that you could put that aside and listen to the case with an open mind and presume him to be innocent?
No, not from the very beginning.
All right, thank you, ma'am. State.
State moves.
Any objections? All right, thank you, ma'am. We appreciate your honesty. You're free to go. This is not the case for you.
Thank you.
Thank you. Have a good day.
You too. Oops, sorry.
Juror in seat number 12. Good morning.
Morning.
Can you hear me?
Yeah.
Okay. You're juror number 780, right?
Yes, ma'am.
All right. Ma'am, we're going to be asking you some questions. No right or wrong answers, just what you actually think or believe.
Okay.
Just be honest and you'll be fine, okay? You indicated that you had heard something about this case, is that correct?
Yeah, on the news.
Can you tell me what you've heard? You're very soft-spoken. Can you speak up a little bit?
It's just what happened, basically.
All right. How many news stories have you seen about it?
Like 3 or 4.
All right. And when did you first see a story about it? Approximately.
Around the time it happened, 2017.
Okay. And did you keep up with it after that?
Not until he's gone to trial again now. I know that.
Going to trial for this case or the
Yeah,
other case?
this case.
Did you follow the other case?
Yeah.
Okay. Did you watch any of the other trial?
No.
Did you talk about this with friends and family and coworkers?
My grandma and my dad.
Okay. Were they following it too?
Yeah.
So you formed an opinion as to whether he's guilty or not?
Kind of, yeah.
It's okay if you have. Like I
Yeah.
said, all we're looking for is the truth. All right, so what is your opinion?
Guilty.
Jurors are required to be able to assume that Mr. Loyd is innocent until and if the state proves him guilty. Can you do that, or would you start the trial believing him to be guilty?
I would probably start the trial believing that he's guilty.
All right, thank you, ma'am. Stay. Any objection? All right, thank you, ma'am. You're free to go.
Thank you.
All right. Returning, did you have a successful? All right, returning to panel number 3, I need the juror in seat 57, please. Good morning.
Good morning.
How are you, ma'am?
I'm doing well, thank you for asking.
Can you hear me clearly with the mask on?
Yes.
Okay, great. We just have a few questions for you this morning. I'm going to start, then the lawyers will have a chance to ask you questions. As much as you can, try to relax. I know this is a strange situation, but we're not looking for a particular answer. There really is no right or wrong answers to these questions. There's just what you think and feel. So just be honest with us, okay?
Okay.
You indicated that you'd heard something about this case. What have you heard, ma'am?
I know it occurred in 2019, because that's when my sister passed. I don't remember so much of the details. I don't watch really so much news. I have the internet, but I use just streaming channels, Hulu, Netflix, stuff like that. So I wasn't even aware of what you just disclosed
About Ms. Dixon?
Yes. So yeah. So I knew about it because it was when it around happened, but I don't know
When you
all
say-
of the details that surrounded it, if
So-
that makes sense.
When you say you knew about it, you knew about the shooting involving Lieutenant Clayton?
No, I just remember that there was a man who shot his pregnant wife or girlfriend, and then law enforcement officer was shot.
Okay.
But if you asked me the name, I couldn't tell you what name it was.
All right. So based on anything that you heard or anything that, did you ever talk about it with anybody that you can remember?
Not so much.
Okay. So based on anything that you've heard or any conversation you may have had, have you formed an opinion as to whether or not Mr. Loyd is guilty?
No, I have not.
All right. Jurors are required to presume him to be innocent until and if the state can prove he's guilty beyond a reasonable doubt. Do you believe that you can presume Mr. Loyd to be innocent?
Yes.
Okay. So, moving on to the death penalty. Do you have any religious or moral objections to the death penalty?
I do not.
Okay. Are you someone that believes that if you're convicted of first-degree premeditated murder, death should be the automatic sentence?
I don't believe it should be the automatic decision. I do feel that's the most restrictive. So it would have to be something, in my opinion, just very egregious that most of society would agree of the crime to consider the death penalty.
Okay. You understand that in Florida, we don't have an automatic death penalty for anything, all right? Is there any case, when I say case, I mean type of case, where you would automatically vote for death?
I don't believe automatically.
All right. And this case involves a law enforcement officer. Is there anything about that that would cause you to automatically vote for death?
No.
All right. You heard me describe the process. You listened to all the evidence, then you go back, weigh the aggravators, mitigators. If you went through that whole process, you'd weighed the aggravators, you'd weighed the mitigators, you've got all the evidence, all the facts, and it's time to make a decision, for you personally to make a decision, because it's an individual decision. If you thought that life without parole was the appropriate sentence, would you be able to vote for that?
Yes, if I thought that was the appropriate sentence based on what was presented as evidence.
Right. And conversely, if you thought that death was the appropriate sentence, would you be able to vote for that?
Yes.
All right. You heard me explain that Mr. Loyd has raised the defense of insanity. Defense has to prove it by clear and convincing evidence. This is guilt phase of the trial. You're trying to decide whether he's guilty or not. If at the end of that trial, you've heard all the evidence, heard everything, you believe, you're convinced that he was insane at the time of the offense, would you be able to vote not guilty?
If they were able to prove that particular defense, that he was insane at the time of murder, yes.
Okay. And then lastly, as I told you, he's been previously convicted of the murder of Ms. Dixon and her unborn child and sentenced to life. You can't use that to decide whether or not he's guilty of this case. You understand that?
Correct.
Do you feel that you would have any problems putting that out of your mind during the guilt phase of these proceedings?
No.
All right, thank you, ma'am. I don't have any other questions for you, but the attorneys probably will. Mr.
Okay.
Williams, you may inquire.
Yes, Your Honor. Good morning.
Good morning.
So you are the grand prize winner because you filled out a little sheet of information for us when you first came in.
Yes.
And I go through that and I look for certain things and I circled like every one of yours.
Okay.
So I'm going to ask you some questions about that before we go
Okay.
any further about the death penalty. When you listed your current occupation, you listed clinician with OPD. Is that the Orlando Police Department?
Correct.
Okay. How long have you Well, do you work in-house for them, or is it contracted? Can you tell me the nature of your job as it relates to the police department?
My current role is the licensed clinician for the community response team. That started in February 28th. So basically what I do, I am a mental health first responder for mental health illness and substance abuse. We are dispatched by 911, and I assess for crisis whether the individual needs to be Baker Act or Marchman Act. If that is the case, then we request transportation by Orlando Police Department to transport to Aspire. So I am employed by Aspire, but the pilot program is funded by the Orlando Police Department.
I was going to say, you said you started in February of this year?
February 28th.
February 28th?
Correct.
Can I see the attorneys at the bench for one moment, please? Excuse me, ma'am, we'll be right with you.
Yes, Your Honor.
Sorry, ma'am. Go ahead, Mr. Williams.
We always wait for that nice young lady to sit down so she can start typing. Okay, so that's a new program, but if I understand what you're telling me, you go out and assist law enforcement on cases where there might be a individual suffering a mental illness and help evaluate that?
Correct. I am first on the scene, and if law enforcement is needed, per statute, they have to transport to Aspire.
So do you arrive before the police?
For the most part, correct, yes.
Okay.
They send us on nonviolent mental health calls.
Yes, ma'am. Whereas in the past, law enforcement would have gone out without you. Is that your understanding? Okay.
Correct.
Are you a licensed clinician in some way? Do you have a license?
Yes, I am a licensed mental health therapist.
Okay. And how long have you held that license?
I've been licensed for a year, but working in the mental health field for about 20 years since I graduated.
Did you have your own practice prior to that?
I have a business, not my own practice.
Okay, you have a business.
I have a business on the side, yes,
Okay.
I do.
You were previously a juror?
I have served
Okay, how many times?
once,
Here in Orange County?
yes.
How long ago?
I have to say over 7 years.
Over 7 years?
I would have, yeah.
Okay. That's it. You look like you're struggling with your memory, but that's a pretty specific number, so good for you. Was it criminal or civil?
It was criminal.
And do you remember the nature of the charge?
That particular was a convicted felon with ammunition.
Ammunition, right? Did you guys actually have an opportunity to deliberate on the charge?
Yes, we did.
Right? Were you the foreperson?
No, I was not.
Don't tell me what the verdict was, but did you reach a verdict?
Yes, we did.
What were your thoughts on that experience, on being a juror?
Throughout the entire process?
Yes, ma'am. Good, bad, anything you want to tell me?
It went as I would have expected. Prosecution, their case, the defense put on their case, and we deliberated. It was a half a day trial. Everyone was able to review the evidence, talk it through, and we were pretty much able to reach the same decision in a quick amount of time. So.
Okay. Good experience? Bad experience?
Yeah, it was a good experience.
Good experience. Okay. You also answered yes to the question, have you or a member of your family been accused, a complainant, or a witness in a criminal case?
Yes.
Can you tell me who you were referring to?
My sister, the one that passed in 2019, was a Orange County sheriff detective. My brother is actually incarcerated. He actually stole the weapon from my sister, the deputy sheriff, and he was convicted.
Is he incarcerated now?
He is.
Okay. And you said your sister was a deputy, and I'm sorry to hear about her passing.
Thank you.
Obviously, the court has already told you that we're here on the allegation the law enforcement officer was murdered, and your sister, who it sounds like you were close with, was a law enforcement officer.
Yes.
Would you be able to set aside any feelings you have about law enforcement and render a fair and impartial verdict on this case where the cop?
Yes.
Right? Anything about your brother's experience with law enforcement that you think would make it hard for you to believe or disbelieve law enforcement officers?
No, I am aware of what he did. So
Okay.
he did the crime, so he had to face the time. So,
Yes, ma'am. Did you feel he was treated fairly? You kind of suggested that he was, but
Yes.
okay. You said that you had no religious or moral objections to the death penalty, but indicated that, in your opinion, just your opinion, it would need to be an egregious situation.
Correct.
Because it's the ultimate punishment, I'm assuming. Okay. But I think I also heard you tell the court that you believe that if you thought it was warranted under the laws as described to you by the judge, that you could personally, not hypothetically, but in a very real situation, vote to impose a sentence of death if that's the way you felt.
Yes.
All right. Do you think you would struggle at all with an insanity defense, given your, what I'm assuming is a significant knowledge base?
Do you think I would struggle in reaching that, believing the defense?
Let me ask a better question.
Okay.
How do you think your background would shape the way you approach that defense and listening to the evidence, if at all? There are circumstances where insanity is a defense. So honestly, I would have to look at all of the evidence and determine at that particular time of the crime, was he innocent? I mean, I'm sorry, not innocent, but if he was insane or not. And like the judge said, that's going to come from the defense. So that's going to depend on the evidence that they
portray as the, for the insanity defense, honestly.
Are you familiar with the test for, or the elements of insanity through your career?
Actually, no, not so much.
Okay. The reason I ask is you said at the time, and actually that is the relevant question under the laws, was the person insane at the time of the crime, not if they ever have been in the past. So, but what I heard you say, I believe, is that you recognize that it is possible for a person to have a mental illness and for that mental illness to affect them in a way where they would not be criminally responsible.
That is possible.
If it's possible, well, have you ever encountered anyone in your career or personal life that you concluded was feigning mental illness for a separate purpose?
Yes.
So am I safe in assuming that you recognize that both of those things can happen?
Yes.
Which is why I'm assuming that that's why you'd want to review the evidence.
Correct.
Right. You've already told us a lot about your life, and I appreciate your openness. Is there anything that we haven't discussed that you think is significant, given the specific nature of what we're trying to do here, and that we're trying to find fair people, that you think we should know about you?
I guess for me, with my background, with experience with law enforcement, I honestly believe confidentiality. I believe, that there are cases that people are, sentenced, are declared insanity. Obviously, that is, considered evidence. I am a very fair person. I have to look at, even in my line of work with, making critical decisions. I have to be fair. I cannot let my own personal bias, affect any part of my personal job. And if I was chosen as a juror, it would be the exact same way.
Okay. I do have one more question, if it's okay, Judge. One more question. If on a scale of 1 to 10, if number 1 is you can't wait to get out of here and go do anything but this, and number 10 is you're very excited about the prospect of being a potential juror, where would you rate yourself on your desire to be a part of this process in this particular case?
Without taking the sequester part out.
No, you gotta include that.
I would say 7. I would say 7.
And why is that?
I do feel that because I don't know so much of the case, because I don't do a lot of social media, that I can be fair and rational. I have the time to do so. My job allows that. I don't have any other interference going on. I'm not distracted by anything else. So contemplating someone's, life is something to be taken seriously. And I just feel at this particular time in my life that I do have that fair and objective persona to do that.
Okay. Thank you so much, ma'am. Thank you, Your Honor.
Thank you, Mr. Williams. You doing it? Okay. All right.
Good morning.
Good morning.
My name is Allison Miller.
Are you mic'd up?
I am.
Okay, go ahead.
I chalk with my hands, so there's a good chance I'm going to knock it off, but I will
All right.
try.
Good.
I just want to follow up with a couple questions about your employment with the Orlando Police Department, if that's okay. Obviously, it's been made clear that this case involves the death of Lieutenant Clayton. And Mr. Loyd has pled not guilty by reason of insanity. And so the question is, you are a civilian who works with law enforcement, correct?
Correct.
But knowing that you work with law enforcement, would you be able to render a verdict of not guilty if the evidence supported it, knowing you got to go back to work with a bunch of police officers?
Yes.
Okay. The way you said that doesn't seem to indicate you have any hesitation about that.
No, I don't.
Okay. And the judge asked you at the very beginning of this if you would automatically impose a sentence of death once you, if you were selected as a juror, made a decision that the defendant was guilty of first-degree murder. Do you remember that?
Yes.
And so I just want to ask you a few follow-up questions about your feelings on the possible penalties for first-degree murder, which in Florida are only life without the possibility of parole or the death penalty, okay?
Yes.
And so I know we're on the same page, and I'm sure you probably know this. I just want to define first-degree murder a little bit further.
Okay.
It is the intentional, premeditated killing of an innocent victim. That defendant thought about it, meant to do it, and did it.
Yes.
With me?
Yeah.
And if a defendant was convicted of first-degree murder, a jury would have unanimously rejected any defenses available to that person, okay?
Okay.
Those defenses might have included things like self-defense, defense of others, duress, somebody had a gun to his head and made him do it, heat of passion, did he walk in and catch his wife in bed with another man? But none of those things would have applied if the jury convicted that defendant of first-degree intentional premeditated murder.
Correct.
Similarly, if a jury finds a defendant guilty of first-degree murder, that jury would have excluded or rejected the defense of not guilty by reason of insanity.
Correct.
The defendant would have also not been intellectually disabled, what we formerly referred to as mental retardation. Along the same lines, that defendant wouldn't have been so drunk or so high that he didn't know what he was doing. Knew what he was doing, knew right from wrong, chose wrong. And lastly, it wasn't a mistake, it wasn't an accident, and the police definitely got the right guy. With me? So my question is, what are your feelings about the death penalty in that circumstance being the only appropriate penalty for that guilty murderer?
Objection.
May I respond, or would you prefer it sidebar? Yeah. Let's back up.
Okay.
Did everything I ask or state make sense? Tell me where I was confusing.
I was trying to understand exactly what you're asking about the sentencing phase.
Okay. And so you understand for us to get to a sentencing phase.
Correct.
Or a penalty phase, the defendant has to be first found guilty of the intentional premeditated killing of an innocent victim.
Correct.
And so I wanted to make sure we understood that to even get to that penalty phase, if a jury finds a defendant guilty of first-degree murder, all of those defenses, excuses, justifications would have been eliminated by that jury in getting here.
Correct.
And so, do you understand what first-degree murder is?
Yes.
Okay.
So premeditated.
Yes, ma'am. The intentional premeditated killing of an innocent victim without legal justification or defense.
Correct.
So knowing that, does the death penalty become the automatic penalty, understanding the definition of first-degree murder?
No.
Why not?
Because there could be mitigating circumstances, and there, like the judge said, there is the option of life without parole. So I don't see myself going directly straight for the death penalty, if that makes sense.
It does. And I think a lot of people feel the same way. I just want to make sure I understand you. When you talk about mitigating circumstances, what comes to mind when you mention that?
Sustained. Rephrase.
Would life in prison be sufficient enough penalty for the guilty murderer of that innocent victim that we discussed?
I cannot, without all the evidence, I can't really say 100% for sure,
Okay.
if that makes sense as well.
It does make sense. And, it's tough because we're asking you to offer or share your feelings in kind of a vacuum. But this is my only opportunity to
do
speak to
so.
you, right? We may not even get to that second part of the trial,
Exactly.
right? But the law requires that I have this conversation about possible penalty now. So please don't hold that against Mr. Loyd. When we talk about mitigating circumstances, if you were living on an island and you were the queen and you got to make all of the rules, are there things that you believe you would need to know or you should know to make a decision about whether someone lives or dies?
Yes.
And like what?
Background, and background just meaning in terms of perhaps trauma, prior criminal history, the person's character, significant things, medical issues, if they have substance abuse issues, if there's any type of neurological issues, traumatic brain. So, a lot of those things I would have to kind of, take into account.
And I just want to make sure we're on the same page. When you talk about background, you're talking about that defendant's background and all of those things, correct?
Correct.
Let me ask, and there's a lot to unpack there, and I want to do that. Before I go there, does the fact that a victim is a law enforcement officer make death the automatic penalty for you?
No.
Okay. Couple things you mentioned about the defendant's background, like prior criminal history. Tell me how that plays into your decision.
I would say the history, not necessarily the particular crimes or how if they were guilty or not guilty, but just that history of it. Is it a repeating factor? Did it start, in childhood, let its way up into adolescence? Is it a pattern, if that makes sense?
It does. And tell me, though, how that affects your decision about whether life or death is the appropriate penalty. If somebody has that pattern of criminal history, is that...
Well, that wouldn't be the only...
Hold on. Sustain. Move on.
That would be one factor you would consider in the totality of circumstances?
Correct, not the only one.
If you heard someone had a prior conviction for murder, would death become the automatic penalty for this murderer?
Sustained.
Can we
Move
approach
on.
on that, Your Honor?
Nope. Sustained. Oh, I'm sorry. You can ask, I'm reversing myself. You can ask that particular question.
Would you mind repeating what the exact question
Ma'am,
was?
the question is this: if you heard someone had a prior conviction for murder, would death become an automatic penalty for this murder?
No.
Thank you, ma'am.
Thanks.
When we talk about the defendant's background, if a defendant has been exposed to the effects of racism throughout the course of his life, is that something that you would give meaningful consideration to?
Racism?
Yes, ma'am. The effects of racism.
In terms of the death penalty?
Right. So when deciding whether life or death is the appropriate penalty, obviously Mr. Loyd is African American.
Correct.
If you heard evidence about a defendant experiencing the effects of racism, and let me clear something up too before I ask that. Mitigation can be absolutely anything to anyone.
Okay.
right? Aggravation is limited to one of 16 things by law in Florida.
Okay.
Mitigating circumstances can be anything to any juror and can include your own personal sense of mercy.
Objection.
Sustained.
Mitigation can be
Mercy,
anything.
yeah. And let me clarify. Mercy is not mitigation, ma'am, all right? Mitigation is anything that relates to the character of the defendant, the defendant's background, or the circumstances of the offense. You may proceed.
And so relating to the defendant's background, understanding that mitigation is a much more voluminous idea than aggravation, it could include that defendant experiencing the effects of racism. And so I'm asking you if that's something you think you could give consideration to when deciding whether life or death is the appropriate penalty.
I try to see how to answer the question. If it's for insanity defense, I'm not sure how racism would play into that.
Let me clear that up.
Okay.
So insanity is something, if you're selected to be a juror, that you're going to decide in the first part of the trial.
Okay.
So if the defendant is able to establish that he was insane at the time of the crime, he would be not guilty.
Correct.
So we wouldn't even get to that second part when we're deciding sentence.
Correct.
With me? Mitigation is if we're in that second part, why any juror might choose life and not choose death. Does that make sense?
Yes.
And so mitigation is not an excuse or justification, but is a reason why a juror might say, I think life is the appropriate penalty in this case. With me?
Yes.
And that could include the defendant experiencing the effects of racism. You seem hesitant. Tell me what you're thinking, please.
Okay, so I guess what I'm thinking, I don't see racism playing a part in that factor.
Okay. Well, let me ask you, you mentioned trauma being something you would want to know about.
Correct.
Do you think the effects of racism could be traumatic to a particular person?
Objection.
Sustain. Move on.
This has been mentioned several times, but death is never required. Not in any case. Not in this case, not in the worst imaginable case you could think of. With me?
Correct.
And we've talked a little bit about this. Mitigation, we've thrown that around a lot, is why any juror would choose life or not choose death. And it does not have to be unanimous. Each juror could say, I find this to be mitigating, and another juror could totally disagree. Are you okay with that?
Correct, yes.
And the law gives great power to each individual juror in Florida, right? If one juror decides that life should be the penalty, then life will be the penalty. Are you okay with that?
Yes.
In order for a just verdict to be returned in this courtroom, all 12 jurors' individual moral assessments have to be reflected on the verdict form. So there's one signature from the foreperson, but that foreperson's really just signing off saying, this verdict reflects all 12 people's individual moral assessment.
Yes.
And it would be a miscarriage of justice if not all 12 people's individual moral assessments were reflected on that verdict form.
Correct.
It's your duty, if you're selected, to make sure your individual moral assessment is heard in this courtroom.
Correct.
Right?
Yes.
We're talking about whether somebody lives or dies.
Correct.
And you could do that.
Yes.
Sometimes these things can get contentious, right? You would imagine 12 people may not all agree on something like whether somebody lives or dies.
Absolutely.
And that the law encourages you to deliberate, which means to carefully consider. But if you have reached a verdict for life and it's not being respected, you can say, we're done here. Go ahead and write the verdict down, get the bailiff, get the judge, I've reached a verdict.
Yes.
You could do that.
Yes.
May I have just a moment, Your Honor?
Yes, ma'am.
I have nothing further, thank you.
All right, thank you. Either side wish to approach?
No, ma'am.
State?
No, Your Honor, we do not.
All
I'm
right.
sorry.
Thank you. All right, ma'am, we're going to send you through to the final round of questioning, and that is the final round. We will be choosing the jury that day.
Okay.
And that means that you are now no longer a green dot, you're now a purple dot.
Purple.
You're purple. We're going to give you a new dot.
Okay.
The colors are just for when you phone to the jury room. They call jurors by colors because there's too many of you to call the numbers, all right?
Okay.
So starting Friday after 5, call Friday, call Monday, listen for purple dots returned to the courthouse on this date at this time.
Okay.
Okay? Because it's final jury selection and we are picking a jury that day, you need to have packed in case you get picked. You'll be sequestered that day. Leave your suitcase in your car. If you get picked, we'll make arrangements for it. If not, you just go home and unpack.
Okay.
All right? Any questions?
No.
All right. Thank you so much. Have a good day.
You too, Your Honor.
Thanks. Can I have the juror in seat 59, please? He's going to be our last juror before the lunch break. Good afternoon. I'm sorry, she's requesting a hearing aid? Can you hear me? No? Okay. Can you hear me now? Okay, can you answer out, you have to answer out loud. Can you hear me? Is that a yes?
Yeah.
Okay. How are you this morning, or actually this afternoon? Do you speak English, ma'am?
No.
Okay. Is your native language Spanish? Do you understand?
Español.
Do you understand what I'm saying? No? Un poquito?
Poquito.
Okay. State.
State motion.
Defense. All right. Does anybody object if I explain in Spanish to her that she's excused so she knows what I'm saying? All right. Ok. Yo lo voy a excusar del jurado. Que tenga buen día. Muchas gracias. Okay. All right. All right. That's it for now. I did send that is the end of panel 3. When we come back, I've asked panel 3 to return at 1:15. We'll start with panel 4. Lunch break. Court's in recess.
Your Honor, the cite to the case regarding the Colorado method hypothetical that was just discussed is OGMV State 3077.
Wait. Can't hear you. Hold on. And what the heck did I just do with my pen? All right, here's one. Go ahead.
The citation to the case dealing with the Colorado method hypothetical that defense counsel just tried to just use is OJMV State, HOJAN 307 Southern 3rd 618, Florida Supreme Court 2020.
And which hypothetical? She used a couple of hypotheticals. Which one?
If, let's say he killed an innocent person, it wasn't self-defense, there's no intellectual disability.
Okay. All right, thank you. Anything else? All right, have a good.
You didn't have an opportunity to sidebar. I would object for sustaining state protection of right to mercy. The case of Woodson, I don't know, for that response, I disagree with the state's assessment of programs against war. But as the report's ruling on not being able to suggest mercy for mitigating circumstance, Woodson v. North Carolina, 428 U.S., specifically at 303. I'm sorry, can you repeat? I'm sorry. Oh, I don't know.
Yeah, you guys have to remember, turn your mics on.
Sorry. The case that stands for mercy as a mitigating circumstance is Woodson v. North Carolina, 428 U.S., specifically at 303. Quote, the jury must always be given the option of extending mercy.
I did not say that they could not extend mercy. What the court's ruling was very clearly is mercy is not a mitigator. I did specifically tell the juror, you can extend mercy. All right, I just wanted to clarify the record on that. All right, thank you, folks. Lunch, 1:15.